Chapter 27 Condominiums and Cooperatives Introduction. Objectives. In this chapter, we will discuss issues surrounding condominium and cooperative ownership. At the end of this chapter, you will be able to 1. Describe the principal documents that legalize the formation of condominium dwellings, including the declaration, articles of incorporation, bylaws, and offering plan. 2. Identify the various legal instruments and procedures involved in offering, acquiring, and flipping a condominium unit. 3. Describe key issues that impact the buyer in a condominium purchase, including CCRs, closing costs, title insurance, taxes, and financial qualification. 4. Characterize the legal concept of a cooperative and describe the documents and procedures involved in the legal organization of a cooperative. 5. Describe the co-op board package, the buyer approval process, and the legal concept of the condop. Key terms. There are several important terms in this chapter. Remember to pay particular attention to these terms when you see them. Alteration Agreement, flip tax, board package, flipping, bylaws, house rules, common elements, letter of intent, condominium, maintenance, condop, offering plan, cooperative, proprietary lease, covenants, conditions and restrictions, recognition agreement, declaration, share loan. Sponsor. The New York Bureau of Educational Standards requires that you spend 200 minutes studying the material in this chapter. Your course timer can be found in the upper right-hand corner of your screen. Introduction. Residential homeownership consists of an array of ranch styles, split levels and multiple-story single-family homes. It also includes 2- and 3-family dwellings. As a real estate agent, you will become well-versed in the ins and outs of the sale and purchase of these types of homes. But among the more complex types of residential dwellings are condominiums and cooperatives. In addition to the issues that surround the purchase of a more typical residence, buyers of condos and co-ops must deal with such concepts as condominium documents, homeowners associations, common and limited common elements, maintenance assessments, special assessments. Additionally, condo and co-op owners will have to deal with complex financing and taxation issues. Essentially, when a buyer purchases a condo or co-op unit, he or she will be living with other owners who made a similar purchase in the same building. Neighbors are separated by walls, floors and ceilings. They are not on a physically separate piece of land in a physically separate building. Owners will share elements such as elevators, hallways, parking areas, swimming pools and other areas that belong not to just one resident, but to all residents who own property in that building. Common elements such as these are governed by rules and regulations that all residents are bound to follow. That is the nature of condo and co-op living. In this chapter, we will discuss topics that are unique to the world of condominiums and cooperatives in an attempt to make it easier for you to help your buyers navigate through the complexities of each type of housing. Condominium definition. A condominium is a building in which each owner has a percentage ownership of the entire property. A condominium can be residential, commercial, or industrial, but we will direct our discussion mostly to residential condos. Condominiums have 3 essential characteristics. 1. The condo owner owns his or her individual apartment just as if it were a private home. It is for legal purposes real property. The owner will receive a deed for the unit and the property can be held in severalty, as a joint tenancy, as tenants in common, or as tenants by the entirety. 2. The condo owners own an undivided percentage of the common elements of the building along with the other unit owners. These common elements include the land and the improvements, such as hallways, elevators, health club facilities and other areas common to the building. The individual owner's share is usually determined by the square footage of his or her unit. The land and common areas are owned as tenants in common. 3. The condo is governed by a board of directors or board of managers that maintains the common elements and enforces the regulations. The condo owners are also subject to any state laws that govern condominiums. The condo rules are specified in the condominium documents and govern such things as the association dues, the hours the swimming pool is open, and whether or not pets are allowed. Condominium documents. Condominium documents are the legal blueprint of the building. They are generally divided into three parts. Declaration. The declaration explains the nature of the development project. It identifies the name of the condominium, the developer, and the principal officers. It describes the units, the way the condominium is governed and how the dues will be assessed. It outlines repair and maintenance responsibilities and describes the ownership interest between the condo association and the owner. The declaration is recorded in the public records of the county in which it is located, at which point it becomes effective. Articles of Incorporation. This document describes the rights of the unit owners. It covers a number of issues from the rights and duties of the board to whether or not the unit owners can have pets. It generally includes key issues such as rental policy, vehicle parking rights, limited common elements, leasehold obligations, and storage facilities. Even though this may be a long document, it is often easy for the lay person to understand. Rules and regulations. This document explains the implementation of the day-to-day activities in the units. It talks about items such as how pets can be transported through the building, what hours the swimming pool is open, the use of the elevators, and the general etiquette in the common areas. Condo issues. Bylaws. The bylaws are the basic rules under which the condominium operates. The bylaws, among other things, specify the number of members on the board. Detail the nature of the officers and their duties. Identify the manner in which the board members are elected. Define the requirements of the annual shareholders meeting. Describe the voting rights of each owner. Set forth the number of seats a sponsor can have on the board of directors and when the sponsor must give up control. Describe any sublet provisions. Identify any restrictions on the use of the units and common areas. Describe the owner's obligations to make repairs. Define the method for making changes to the bylaws. Role of the sponsor. The condo's sponsor is the condo's owner or developer. The sponsor appoints the board members. Appoints the managing agent. Puts a limit of his or her own control of the board. When a condominium plan is approved, the sponsor usually owns all or most of the units. The sponsor also controls the board and the managing agent. It is permissible under regulations issued by the State Attorney General for a sponsor to retain board control in a new development until all units have been sold, as long as it was fully disclosed both in the bylaws and in the special risks section of the offering plan. For condominiums that are created in existing tenanted properties, however, the regulations require a sponsor to give up control of the board after 5 years or upon the sale of at least 50% of the units, whichever occurs first. New or existing development. When choosing a condo or co-op, buyers look at all the same factors that they would if purchasing a private residence: location, size, available services, and price. But there are other factors that buyers need to consider. Should they purchase a newly constructed unit or should they buy into an already existing building? When making that decision, there are a number of things to investigate. Reading the offering plan. An offering plan, also known as a prospectus or black book, is intended to help buyers make an informed decision about their purchase. Before the plan can be distributed, it must be reviewed by the New York State Attorney General's office to be sure the information is accurate and complete according to New York State legal requirements. The regulations enforced by New York regarding the content of the offering plan for the sale of co-ops and condos require detailed disclosure by a sponsor of what is planned to be built for newly constructed properties, and detailed disclosure of the condition of the property for existing buildings. The offering plan will contain specifics about the project, including such things as how many units will be available, the size of the units and floor plans, common areas, recreation areas, landscaping issues, parking spaces, appliances and amenities. Buyers should carefully read the description of property section in the offering plan to determine the sponsor's obligations. If something is not specified in the offering plan, the sponsor is not obligated to provide it. Offering plan. Special risks. It's important for buyers to read the offering plan carefully. Sometimes what is listed in the offering plan is not what is actually delivered by the sponsor. Buyers should not rely on advertising brochures or any verbal statements or architectural renderings. For example, in most developments, sponsors install minimal but adequate landscaping, and when purchasers want an upgrade of this item, they must pay for it themselves. Real estate tax validation. The exact amount of property taxes on a condo may not be known until the project is actually completed. The financial section of the offering plan will give the projected real estate taxes for the condo. This projection is based on the current tax rate, the assessed value the municipality places on the property, and any tax abatements the developer may be entitled to receive. Many new developments receive tax abatements that result in very small, or even non-existent, taxes for the first several years after the building is completed. In any case, the exact taxes will not be known until the project is completed. Floor plans. The offering plan should have detailed information about the floor plans of all the recreational facilities and buildings, as well as each of the individual living units. Offering plan. Price increases. There are circumstances when the price of a condominium may increase during the development cycle. We'll talk more about why this happens a little later in this chapter. Hidden costs. Sometimes purchasers think they are getting one thing and actually end up with something else instead. For example, the sponsor may substitute a different brand of appliance from what was listed in the offering plan. Offering plans frequently state that the sponsor can substitute equal or better appliances, but not appliances of lesser quality. In addition, as we said earlier, a purchaser may want an upgrade of an item, such as better landscaping. But when purchasers want an upgrade of this type, they must pay for it themselves. Again, a careful reading of the offering plan will help the purchaser determine if what he or she is receiving is part of the offering or is considered an upgrade that will incur extra charges. Closing date. Sometimes delays in the construction can delay the set closing date. There is usually a statement in the condo contract that deals with closing delays and the rights of the purchaser should a delay take place. Check your understanding. Print this screen, answer the questions, and then advance to the next screen to see the answers. 1. What are the 3 essential characteristics of a condominium? 2. What does a declaration do? 3. Where would one find information about the number of members on the board and an explanation of their duties? 4. What must happen to an offering plan before it can be distributed? Check your understanding. Answers 1. What are the 3 essential characteristics of a condominium? The condo owner owns his or her individual apartment just as if it were a private home. The condo owners own an undivided percentage of the common elements of the building along with the other unit owners. The condo is governed by a board of directors or board of managers that maintains the common elements and enforces the regulations. 2. What does a declaration do? The declaration explains the nature of the development project, including the name of the condominium, the developer and the principal officers, a description of the units, the way the condominium is governed and how the dues will be assessed, an explanation of repair and maintenance responsibilities, and a description of the ownership interest between the condo association and the owner. 3. Where would one find information about the number of members on the board and an explanation of their duties? In the bylaws. 4. What must happen to an offering plan before it can be distributed? It must be reviewed by the New York State Attorney General's office to be sure the information is accurate and complete according to New York State legal requirements. Letter of intent. A letter of intent is a written statement expressing the intention of the undersigned to enter into a formal agreement to purchase a condominium. The letter is a written offer to reserve a specific unit, although the agreement can be non-binding with regard to the exact purchaser or the unit's final price. Usually the letter of intent is used to draw up the purchase agreement. If an existing rental building is undergoing a conversion to a condominium, the letter of intent is used by any tenant who wants to purchase a unit when the conversion is complete. A letter of intent contains the following information. Price and deposits. This section states the purchase price. It also states an amount of deposit called the reservation deposit, which accompanies the letter of intent and is normally non-refundable. It also indicates an amount of earnest money to be paid when the contract is executed. Both the reservation deposit and the earnest money deposit will be held in escrow and applied to the purchase price at closing. Completion date and closing date. The completion date is specified, subject to delays beyond the control of the seller. The closing date is generally set to be 30 days after the completion date. Use of the unit. For residential units, this section typically states that the unit is to be used for single-family residential purposes only. Non-exclusivity. Buyer agrees that in absence of an executed contract, the seller may continue to market the unit. If the seller finds another buyer, the seller will notify the first buyer who will have a specified period of time to deliver a contract to the seller or the letter of intent will be cancelled. Letter of intent. Legal ramifications. A letter of intent may have a clause that says the letter is not a specific offer or a legally binding obligation. If the letter is non-binding, there are no legal damages to either party if one party defaults on the letter. However, in most cases, the letter is intended to create a binding agreement between the buyer and seller. In such cases, both parties are under the obligation to the other with respect to the performance of the terms of the letter and the proposed sale and purchase of the unit until a contract is agreed upon and executed by both parties. When that occurs, the contract supersedes the letter. If the letter is binding, it should stipulate what will happen if one of the parties defaults. How to submit a letter of intent. A buyer should send a copy of the letter of intent to the sponsor or the sponsor's agent. The sponsor or the agent will revise the letter if it needs to be revised. The buyer should give a copy of the letter to his or her own attorney. CPS1 phase. Sometimes developers may want to test the market before they offer a condominium development for sale. New York will allow this market inquiry as outlined in Cooperative Policy Statement No. 1. New York allows a developer to do the market test as long as the developer follows these rules. The sponsor must file an application to test the market with the Real Estate Financing section of the New York State Attorney General's office. Market testing can begin only after the Attorney General has accepted and approved the application. No reservations, either binding or non-binding, can be accepted until the offering plan has been accepted for filing. No deposits can be accepted until the offering plan has been accepted for filing. All advertisements and advertising literature the sponsor uses must be cleared by the Attorney General before use. The application to test the market will be effective for 120 days after acceptance. The developer can request a 60-day extension if he or she can provide reasons why the 120 period wasn't adequate. The Attorney General will not grant an application to test the market if the sponsor has already submitted an offering plan for filing. Note: the rules outlined in CPS 1 also apply to cooperatives and properties offered by homeowner associations. Price changes. Condominium sponsors often change the prices on their units. Often the sponsor will set an initial price when the offering is made, but by the time the letters of intent start coming in, the prices may have gone up. Offering plan amendments converted buildings according to the conversion laws in New York. The Attorney General's regulations give tenants the exclusive right to buy their apartments for a certain period of time after the offering plan is presented to them. For 90 days from the date they receive the offering plan, tenants who were in occupancy on the date the offering plan was accepted for filing, including rent-controlled and rent-stabilized tenants, have the exclusive right to purchase their apartments. During this 90-day period, the tenant's apartment may not be shown to a prospective buyer unless the tenant has, in writing, waived the right to purchase. Also, during this 90-day period, the sponsor can negotiate prices. So, if the sponsor wants to offer a 15% discount to a tenant, the sponsor must offer that discount to every tenant and submit a proposed amendment to the offering plan to the Attorney General for review and acceptance. Once accepted, the sponsor can offer the discount. Price changes. Offering plan amendments. New buildings. In a new building, the sponsor may negotiate the price on a unit regardless of what the price may be on any other unit. For example, the sponsor may sell one unit for $300,000 and sell another unit for $250,000 and yet another for $325,000. The sponsor does not need to submit an amendment for these price negotiations. However, the sponsor developer would have to submit an amendment if the price was changing for all the apartments in the building or if the price was changing for a certain subset of apartments, such as all of the apartments in one section of the development. If the sponsor is making a request only for a price change and no other factors are involved, the amendment will be automatically accepted by the Attorney General. This is because the Attorney General has power to regulate the proper disclosure of prices, not the prices themselves. Note, these rules also apply in a building conversion, after the 90-day tenant's exclusive period has expired. Price changes. Why and when developers raise prices? In most cases, the price of a condominium is based on the price per square foot of that unit. Typical reasons why unit prices might increase include the following. The price of the raw land may have increased since the offering plan was filed. Increases in construction costs over the life of a project can cause the price of the unit to increase. If the developer sells off the first block of units very quickly, he or she may decide to raise the prices on the next block. The maintenance charges for the common areas may become costly over time. Current market practices. Some developers believe that when they get close to selling out the units in a condominium development, purchasers will be more willing to pay a higher price to buy in. However, price increases often occur long before the developer gets to that stage. Sometimes developers don't really know what the market will bear when they are selling their first units, so they start out lower but then increase as units are sold. Other factors can also influence the price of unit in a condominium development. For example, in NYC the price of condos in a particular development can skyrocket if a movie star or other famous person happens to buy a unit in the building. In new buildings, prospective buyers often have a hard time visualizing what they are buying. For this reason, many sponsors use scale models, furnished model apartments or videos to give buyers a sense of what they are purchasing. Certificate of Occupancy. As we discussed in a previous chapter, the key document used to certify the legal use and occupancy of a building is the Certificate of Occupancy. The document is issued by the building department and describes how a building may be occupied, for example, a single-family home, a parking garage, a 60-unit multiple dwelling, or a retail store. If a construction project is creating a new building or will result in a change of use, egress, or occupancy to an existing building, a new or amended certificate of occupancy is required. Usually, the developer or the sponsor's representative will contact the building department to arrange for its inspectors to perform the necessary construction, plumbing, electrical, and elevator inspections. The inspectors will issue a CO for each unit that complies with the building code. The building department will issue a certificate of occupancy when the completed work complies with the submitted plans and applicable laws, all paperwork is completed, All necessary approvals have been obtained from other appropriate agencies, all fees owed to the building department are paid, and all relevant violations are resolved. A new building cannot be legally occupied until the building department has issued either a final or a temporary certificate of occupancy. A CO is often required when selling a home or refinancing a mortgage. Certificate of occupancy. A temporary certificate of occupancy has an expiration date. For buildings in NYC, the expiration date is usually 90 days after its date of issuance. This means that even though the building department has established that the building is safe to occupy, the approval is only temporary and is subject to expiration. If a TCO expires and is not renewed, a new buyer may find it difficult or impossible to renew his or her homeowner's insurance policy or to sell or refinance the home. The building department strongly recommends that buyers negotiate a closing based on a final CO, not a TCO. A buyer of a co-op, condo or house that has a TCO should consult a licensed architect or engineer to determine what work has to be done in order for the building to receive a final CO. Once the property is purchased, the owner has the legal obligation to make sure that the building obtains a final CO documenting its compliance with the building codes and zoning regulations. Because this becomes the owner's responsibility, a buyer should ask his or her attorney to obtain written assurance and sufficient escrow from the seller developer to ensure that the developer actually finishes any outstanding work and obtains the final CO in a timely manner. Flipping is a term used primarily to describe the practice of buying an asset and quickly reselling it for profit. Though flipping can apply to any asset, the term is most often applied to real estate. In the world of condominiums, flipping is the act of buying a unit from a developer as soon as it comes on the market and then reselling the contract to a third party before closing occurs. Some investors have simultaneous closings, having their third-party buyer ready to close minutes after the investor has closed on the unit. Developer's policy. Flipping is a quick turnaround of the unit for a faster profit, but it may only be done with the developer's permission. In a strong real estate market, if the development is a success, the price of the units will go up. In some cases, the developer may act as a broker for the flips to increase profits. The developer sells both the original units and the flipper's units. Sometimes the developer will buy back the unit from the flipper, give the flipper his or her profit, and then sell the unit for a third time at an even greater profit. Flipping issues. The profits on flipping units can range from 10 to 30% of the purchase price, depending on how well the property is doing or how strong the demand is for the property. From an investment standpoint, flipping seems like a wonderful opportunity to purchase a higher-priced property for a small down payment and then sell for an excellent short-term profit. However, the downside for an investor is that if he or she cannot flip the property, the investor must close and carry the unit until he or she can sell it, or, in the event the investor cannot close on it, risk losing the investment capital. As we mentioned on the previous screen, flipping can drive up the prices on the units in a development. It can cause financial problems for buyers who purchase the flipped units for much more than they would have paid if they bought directly from the developer. Also, too many investors in a development can cause instability in the community. In an attempt to reduce the problem, some developers may have a clause in the sales contract that requires an investor to live in the unit for at least a year before it can be resold or rented. In other cases, developers may earmark only a certain percentage of units that can be sold to investors, leaving the remainder for buyers who intend to live in the units themselves. Check your understanding. Print this screen, answer the questions and then advance to the next screen to see the answers. 1. What is contained in a letter of intent? 2. What can developers do if they want to test the market before they offer a condominium development for sale? 3. What can happen if a temporary certificate of occupancy expires? 4. What does the term flipping mean as it relates to condominiums? Check your understanding. Answers 1. What is contained in a letter of intent? Price and deposits. completion date and closing date, use of the unit. Non-exclusivity 2. What can developers do if they want to test the market before they offer a condominium development for sale? Developers can do a market test as long as they follow the rules outlined in Cooperative Policy Statement Number 1. 3. What can happen if a temporary certificate of occupancy expires? If a temporary certificate of occupancy expires and is not renewed, a new buyer may find it difficult or impossible to renew his or her homeowner's insurance policy or to sell or refinance the home. 4. What does the term flipping mean as it relates to condominiums? Flipping is the act of buying a unit from a developer as soon as it comes on the market and then reselling the contract to a third party before closing occurs. Title issues. Since a condominium is real estate, it is important that the title be free of claims by any third parties. Evidence of a good title is accomplished by the seller providing a copy of his or her title insurance to the buyer or the buyer's title company. Through title insurance policy, the title company ensures that the seller owns and can transfer the property free of any claims to the property by other persons. A lender will require title insurance to protect its interest in the condominium unit. But if there is no mortgage, there is no such requirement. Even in a cash deal, the buyer would be wise to purchase title insurance. Buying from a developer is no guarantee that the developer had a good title. It is possible that the developer could have encumbered the property to another and clouded the title. With title insurance, the insurance company will act as a guarantee for the title to the unit. In addition, the title search will protect the buyer against any unpaid bills or liens against the condominium association. If unpaid bills on common areas are discovered, the association could give a sworn statement stating that it is their responsibility to take care of the bills. Deed. As we mentioned earlier, a condominium owner will receive a deed to his or her own unit, as well as an undivided interest in the common areas. The condominium documents, including the covenants, conditions and restrictions, are usually included in the deed. Covenants, conditions and restrictions are limitations and rules placed on a group of homes by a builder, developer, neighborhood association, and/or homeowner association. All condos and townhomes have CCRs. CCRs can place restrictions of almost any kind of nature, as long as the group writing them agree to it. It is a good idea for a prospective buyer to read the CCRs carefully before making the condo purchase. The title report shows wherein the official county records these documents are recorded, by book and page number. The buyer can receive a copy from the homeowners association or the county clerk's office. Closing costs. Buyer's fees. Below is a list of the types of fees that would be the buyer's responsibility at closing. Many of the fees will vary depending upon the sale price of the unit. Appraisal fee. Credit report. Mortgage points minus 1 to 3% of loan amount, if any. Bank underwriting fee. Bank legal fees. Mortgage tax minus $2.05 per $100 for mortgages under $500,000. $2.175 per $100 for $500,000 and up. Title search. Title insurance, about $450 per $100,000. Mansion tax minus 1% of the sales price for sales of $1 million or more. Recording charges. Buyer's attorney. Condo board application. Condo credit report. Managing agent fee. Prepaid expenses, mortgage and common charges to the end of the month. Real estate tax escrow up to 6 months. Move-in deposit, refundable upon completion of move. Move-in fee. Closing costs. Seller or sponsor fees. Below is a list of the types of fees that would be the seller's responsibility at closing. As with the buyer, many of the fees will vary depending upon the sale price of the unit. New York City real property transfer tax minus $25 filing fee plus 1% of the sale price for sales under $500,000 or 1.425% of the sales price for sales of $500,000 or more. New York State transfer tax minus $4 per $1,000 of purchase price. Attorney fees. Bank fees, if any, processing fees for mortgage payoff. Managing agent fee. Move-out deposit, refundable after move-out if there is no damage. Miscellaneous title fees. Note, if the seller is the developer or sponsor, the NYC and NYS transfer taxes would most likely be paid by the buyer. Buyer's concerns. Common charges. Condo owners pay common charges, which are the monthly payments that cover their share of the costs of operating the building, including building upkeep, insurance and salaries for building staff. The initial operating budget is typically set by the sponsor, but it is not always the one that ultimately gets passed by the board. The maintenance charges can increase by as much as 20% during the first year of operation if the owners require more services than were initially planned for. In addition to fees for maintaining recreational facilities, common charges could also include trash removal, landscaping and snow removal. When a condo is sold, the seller must bring all outstanding fees up to date. At closing, adjustments are made for any services the buyer will use that have already been paid for by the seller. Real estate tax. Condos are assessed for tax purposes just like all other types of real property. Each owner pays his or her real estate taxes directly to the city or other municipality. Tax deductions. If the owner has a mortgage on the unit and he or she itemizes deductions, the interest portion of the mortgage payment is usually tax deductible. At the end of each year, the lender should send the owner a 1098 form, which tells how much was paid in interest and points during the year. This is the amount of interest that can be deducted. More buyer's concerns. Right of first refusal. This is the right of a person or entity to have the first opportunity to either purchase or lease real property. The holder of a right of first refusal has no right to purchase the property until the owner actually offers the property for sale. In some condominiums, the Association of Unit Owners retains the right of first refusal on the sale of any unit. When this is the case, the seller of a condo unit may have to get the Board of Managers to issue a waiver of this right for the seller to present at closing. Mortgage recording tax. Mortgages that are recorded in New York are assessed a mortgage recording tax. This is the same tax that we talked about at length in the unit Untitled Closing and Costs. Mansion tax. All residential properties that sell for $1 million or more in New York State are subject to a 1% tax paid by the buyer. The tax was passed when condo properties were much less than what they cost today. If the buyer is paying the transfer taxes at closing, this cost plus the purchase price is used in determining if the mansion tax is applied. If the transfer tax cost plus the purchase price exceeds $1 million, the mansion tax is owed. Buyer financial ability to purchase. For a condo or co-op purchase, the lender is interested in the buyer's finances if they will be making a loan. The Board of Managers is also interested in the buyer's finances in that they want to be certain the buyer has the resources to make the monthly maintenance payments and cover any assessments that may be made. Let's review the process lenders use to qualify their borrowers. If there is no loan, the Board of Managers can use some of the same measures to qualify prospective purchasers. As we discussed in an earlier chapter, lenders use loan underwriters to process loan applications and decide whether to accept or reject the loan. Underwriting will determine whether a borrower and property meet the minimum requirements established by the lender, the investor or the secondary market. In some cases, the lender will require the borrower to obtain default insurance. The borrower purchases this insurance policy to protect the lender from potential losses if the borrower defaults on the loan. In those cases, either the lender is not willing to bear the total risk of the borrower default or the lender may be planning to sell the loan to a third-party investor. If the lender plans to sell the loan to a third-party investor, the lender must consider the underwriting standards those other investors require. Otherwise, the lender may lose the option of selling mortgages later. Income analysis. To qualify for a mortgage loan, A borrower must meet the lender's qualifications in terms of income, debt, cash, and net worth. In addition, the borrower must demonstrate sufficient creditworthiness to be an acceptable risk. When the lender is looking at an applicant's income, he or she must decide how much of the applicant's income is stable and if the applicant has enough stable income to make the monthly payment. Income is considered stable if it comes from a consistent and reliable source. Depending on who the employer is, the income might hold a lot of weight or not so much. Income is also judged on its permanence, in other words, how long it can be expected to continue. Income that comes from permanent employment, government benefits, or some types of investment interest or dividends is favorably viewed. On the other hand, income from temporary employment or unemployment benefits is not considered stable enough for major consideration. Other income. Often lenders will consider other forms of income as stable if they have been a regular part of the applicant's income for at least 1 to 2 years. This could be in the form of bonuses, commissions, or wages from a part-time job. Typically, overtime is not considered to be stable income, unless the applicant can prove that it has been regular and consistent for some period of time. Income analysis. Acceptable income. Secondary income. Lenders will often consider income from sources other than employment. These sources include the following: monthly Social Security payments or retirement payments. These are considered stable income sources. Alimony. This is stable income under certain conditions, such as whether it is court-ordered, how long the applicant has been receiving it, how long it is expected to continue, and how reliable the ex-spouse is in making the payments. Child support. Like alimony, this is stable income if it is court-ordered and paid regularly. Another consideration is the age of the child when the applicant applies for the loan. Since child support typically stops at age 18, the underwriter will realize that the payments may stop during the loan term and take that into consideration. Public assistance. According to the Equal Credit Opportunity Act, lenders may not discriminate against borrowers simply because all or part of their income comes from a public assistance program, such as welfare. So, if benefits are expected to continue for a long period, this can be considered stable income. Dividends and investment interest. These are considered stable income sources, unless the money will be used for the down payment. Rental income. This can be considered stable income if the payments are made regularly. Often lenders will count just a percentage of rental income to account for periods when units are vacant. Income analysis. Unacceptable income. Lenders do not consider some types of income as stable income. This includes unemployment benefits. These benefits are considered temporary income, so they would not be considered stable. Income from other family members. Spousal income is considered in the application if both partners apply for the loan. However, income from other members of the family such as children or other family members who may not be long-term residents would not be taken into account. Temporary jobs. Even if they are full-time jobs, the lender will probably not accept the income as stable. Exception. If the applicant has been working at a particular type of temporary job for a number of years, it may be considered self-employment and pass the stability test. For example, applicant Mary helps small businesses set up their bookkeeping journals. She is not at any one place very long. Once the books are set up and she has trained an employee to maintain them, she leaves. So, these jobs are temporary. However, Mary has been doing this successfully for the past 6 years and making a good income from it. So, the lender might decide that Mary is really self-employed and use the self-employment standards to qualify her. Other financial considerations. Earnings to debt ratios. Once the lender has established the applicant's monthly income, it will determine if that income is enough to pay a loan. The lender will do this by establishing an income ratio and a debt ratio. We talked about these ratios in an earlier financing chapter, so we will just do a brief review here. The income ratio establishes the borrower's capacity to pay by limiting the percent of gross income a borrower may spend on housing costs. A borrower's debt ratio is calculated based on all of the monthly obligations the borrower has, including those items or payments the borrower must make for other debts, such as car payments or revolving charge accounts. Assets. Assets can be financial, such as stocks or bonds. They can be tangible or intangible. An intangible asset would be the cash value of a life insurance policy. Or they can be physical, such as jewelry, real estate, cars or furniture. Lenders typically give more weight to assets that are liquid. Liquid assets are cash or anything that can be quickly converted to cash, such as stocks. Other assets include mutual funds, T-bills, privately held companies, trust funds, gifts, collectibles and retirement assets. Criteria for purchase. Income parameters. In summary, lenders look at the following aspects for bank financing: acceptable and non-acceptable income, earning-to-debt ratios, loan-to-value ratios, fixed rate and adjustable mortgages, mortgage terms. No income verification. Condo and co-op boards consider these aspects: acceptable and non-acceptable income, earning-to-debt ratios, loan-to-value ratios. Asset parameters. Asset requirements for bank financing include down payment, gifts, cash reserves, retirement assets. Asset requirements for condo or co-op admission include down payment, gifts, cash reserves, retirement assets. Check your understanding. Print this screen, answer the questions and then advance to the next screen to see the answers. 1. What are covenants, conditions and restrictions? 2. What is the right of first refusal and who typically has this right in a condominium? 3. What is a mansion tax? 4. To qualify for a mortgage loan, a borrower must meet the lender's qualifications in what 4 areas? Check your understanding. Answers. 1. What are covenants, conditions and restrictions? Covenants, conditions and restrictions are limitations and rules placed on a group of homes by a builder, developer, neighborhood association and/or homeowner association. All condos and townhomes have CCRs. 2. What is the right of first refusal and who typically has this right in a condominium? This is the right of a person or entity to have the first opportunity to either purchase or lease real property. In some condominiums, the association of unit owners retains the right of first refusal on the sale of any unit. 3. What is a mansion tax? A 1% tax paid by the buyer on any residential property that sells for $1 million or more. 4. To qualify for a mortgage loan, a borrower must meet the lender's qualifications in what 4 areas? A borrower must meet the lender's qualifications in terms of income, debt, cash, and net worth. Cooperative definition. A housing cooperative forms when people join with each other on a democratic basis to own or control the housing and/or related community facilities in which they live. Usually they do this by forming a not-for-profit cooperative corporation. The main difference between a co-op and a condo is the form of ownership. While a condo owner actually owns the unit, which is treated as real property, a co-op member does not directly own any real estate. The corporation owns or leases all real estate. Shares of stock. Each unit in a cooperative is allocated a number of shares of stock. When buying into the co-op, a person is buying those shares in the corporation. As part of the co-op membership, the shareholder has an exclusive right to live in a specific unit for as long as the person wants, as long as he or she doesn't break any of the rules or regulations of the cooperative. As part of the membership, the shareholder also has a vote in the affairs of the corporation. Each month the shareholders pay an amount that covers their share of the operating expenses of their cooperative corporation. This maintenance fee, or rent, goes toward the costs of operating the building's real estate taxes, and the debt service on the building's underlying mortgage. Co-op members are entitled to a tax deduction for their portion of the building's real estate tax, their portion of the building's interest payment on its mortgage and the interest payment on their own apartment loan. Due diligence issues. Since shareholders own a piece of the cooperative corporation, it is important for them to know the financial health of the cooperative before they make the decision to purchase. Potential buyers should review the annual financial statement, with the help of their attorney or an accountant, before signing any contract. This review is known as due diligence. It is a good idea to review 2 years' worth of statements. In many cases, a lender will ask a purchaser to submit the financial statements of the cooperative or condominium before it will approve a loan. Understanding the financial statements. When looking over the financial statement, the potential buyer should focus on 4 critical parts. Accountant's opinion letter. Statement of financial position. Income statement. Notes to the financial statement. Let's look at each of these more closely. Understanding the financial statement's accountant's opinion. This letter, addressed to the board of the condominium association or cooperative corporation, will be at the front of the statement. The letter should have the phrase presents fairly and should not have restrictive language such as subject to or except for. If the letter has the words compilation or review, that means the financial statement has not been audited to verify that the information it contains is correct. Generally speaking, a compilation or review opinion means that there is a problem and the prospective buyer should do further investigation to determine if issues do exist. Reading the board's minutes could be very helpful in this investigation. Statement of financial position. This statement is also known as the balance sheet. The balance sheet is a financial snapshot of the condo or co-op that shows assets, what it owns; liabilities, what it owes; worth, assets minus liabilities, which equals net worth; stockholder capital or equity. This snapshot is taken at a specific point in time, usually December 31st, but the statement itself may not be ready for several months after. The important components of the statement include information about the financial resources, accounts receivable, accounts payable and mortgage balances. Understanding the financial statement's income statement. Also called the statement of operations, the income statement shows the stream of activity during a certain period of time, usually 1 year. It tells what has been earned, what has been spent and what is left over. Most cooperatives show a negative net income. This is not a problem. If the income collected is about the same as what has been disbursed, then the depreciation will create a negative income figure. If the depreciation is added back to net income, the result is the amount of positive cash flow that was received by the building. This is the amount of money that will be added to the building reserve fund. It's important to remember that a cooperative's aim is not to make a profit, which would be subject to tax. The building's goal is to cover costs and build adequate reserves. Notes to the financial statement. The notes at the end of the statement serve to clarify the information that was presented. Some of the notes deserve special attention. Note about the mortgages giving maturity date, amount of the monthly payment and any special terms. Note relating to the terms of the lease if the building is on a land lease. Note relating to the reserve funds. The funds should be in appropriate financial instruments and there should be no indication of lending arrangements that show the co-op or condo is borrowing from the reserve funds. Any note that is related to contingent liabilities or legal matters which might describe matters such as a pending lawsuit. Reviewing board minutes. As we said on an earlier screen, reviewing the board's minutes can be very helpful for prospective buyers. Maintenance and assessment history. The income statement shows how much of the budget is being spent for maintenance and repair. Maintenance and repair is the cost of keeping the building clean and operating in a manner that is consistent with the homeowner's expectations. If the expenditures are high, it might mean that the building is vigorously maintained, or it could mean that the building's systems are becoming obsolete and cost more to be kept operational. This might imply that a future assessment or maintenance increase will be necessary to replace a system that has become too expensive to maintain. Conversely, If the maintenance costs are low, it could mean that the building has new systems that are under warranty and not in need of a great deal of maintenance. Or it could be that the building is not being managed correctly or properly maintained. During its scheduled meetings, the board may discuss maintenance issues and make decisions about whether they will need special assessments during the year to cover certain expenses. Reading the minutes will give the prospect an idea of what maintenance issues are of concern to the cooperative board. Reviewing board minutes. Underlying mortgage. Most co-op buildings have one or more mortgages on the entire building. This is what is known as the underlying mortgage. The financing of the co-op's underlying mortgage is one of the most significant factors in the fiscal integrity of the building. The size of the mortgage and the corresponding monthly payments have a significant impact on the value of each individual unit. Before making a purchase, prospective buyers should determine what type of mortgage exists, how many mortgages there are, and when the mortgages will mature. The financial statement will have this information. If the mortgage is maturing soon, it may have to be refinanced, which could be a large expense to the co-op corporation. However, this is not always a negative thing. It is true that once the loan is refinanced, the principal portion of the payment is low and the interest payment is high, but that means the maintenance goes down while the tax deduction goes up. Again, reading the board minutes can give the buyer information about the status of the mortgages that can't be found in the financial statements. Reviewing board minutes. Reserve fund. Information about reserve funds can usually be found in the financial statement, but it may also be addressed in the board minutes. The reserve fund is the money set aside for major capital improvements, unexpected repairs, or replacement of building systems. If the fund is large enough, there may be no need for increased maintenance fees, assessments, or new loans. If there is a shortfall, shareholders might have to absorb maintenance increases to cover the cost of the installation or to pay the interest and principal on the loan. Some co-op boards pass on the expense to shareholders through assessments rather than maintenance fee increases. In general, the reserve fund should be adequate to cover any major capital improvements. Typically, a lender would like to see a reserve fund of at least $1,000 per unit with a minimum of $25,000 per building. Ownership. For the co-op corporation, the ownership of the building and all of the common elements is a fee-simple ownership. For the shareholders, their interest is a leasehold estate. This gives the shareholders the right to possession of an apartment and the use of the common areas. As we said earlier, the maintenance fee covers the upkeep on the building, any operational costs, the property taxes, and the underlying mortgage, if there is one. Shareholders can deduct the mortgage interest and the property taxes for their personal loans for their unit and a proportionate share of the interest on the underlying mortgage. Since the corporation owns the common areas, the co-op shareholders have no tenancy in common in those areas as condo owners do. Flip tax. Some cooperatives have a flip tax that is imposed when the unit transfers. A flip tax is not really a tax but a fee for the sale of a co-op unit. The most popular form of flip tax in the New York City area is a percentage of the gross selling price. The percentage is usually between 1 and 5%, typically paid by the seller but payable either by the seller or buyer of the co-op apartment. Other formulations for the flip tax include a flat fee per apartment, a percentage of the seller's profit, or a straight per share assessment. The cooperative does not pay the tax to the government. The flip tax is a means of generating income for the cooperative building. It creates a cash flow and helps build up the co-op's reserves without raising the maintenance payments. Check your understanding. Print this screen, answer the questions and then advance to the next screen to see the answers. 1. What is the main difference between a condo and a co-op? 2. What are 4 critical parts of a financial statement? 3. Reading the board minutes can give specific help to a prospective buyer in what areas? 4. What is a flip tax? Check your understanding. Answers 1. What is the main difference between a condo and a co-op? The form of ownership. While a condo owner actually owns the unit, which is treated as real property, A co-op member does not directly own any real estate. The corporation owns or leases all real estate. 2. What are 4 critical parts of a financial statement? Accountant's opinion letter. Statement of financial position, income statement. Notes to the financial statement. 3. Reading the board minutes can give specific help to a prospective buyer in what areas? Maintenance and assessment history, reserve fund, underlying mortgage. 4. What is a flip tax? A flip tax is a transfer fee for the sale of a co-op unit, usually paid by the seller. Documents needed for cooperative sale purchase. Since the purchase of a co-op is different from the purchase of the real property of a condominium, the documents needed for the transfer of the property are also different. As we said earlier, co-op residents do not actually buy their individual apartments. They purchase the shares in the cooperative corporation that are allocated to a particular apartment. The contract to purchase the shares is called a subscription agreement. The subscription agreements are prepared by the cooperative sponsor and are included in the offering plan. In addition to the subscription agreement, the documents typically needed for a cooperative transfer include Proprietary Lease, Articles of Incorporation, Bylaws, House Rules, Stock Certificate. When the purchaser closes on a purchased unit, he or she will receive stock certificates in his or her own name. The certificates could be issued 1 per share, or there could be just 1 certificate that states the total shares the purchaser will have. Proprietary Lease. Co-op purchasers do not receive a deed to their property. Instead, ownership of the shares entitles the purchaser to a long-term proprietary lease for the apartment or unit. The lease defines the purchaser's rights and obligations with respect to the possession, use and occupancy of the apartment. The lease is delivered to the purchaser at closing. The proprietary lease is somewhat like a typical apartment rental lease, but it is much more detailed. The items addressed in the lease include the following. Lease term, usually many years. Deposits required. Amount of the monthly maintenance payment and the due date. Obligations of the corporation for maintenance and repair of the building. Damage to the building and rent abatement due to damage. Terrace and balcony use and maintenance. Right to quiet enjoyment. Requirement that all house rules be observed by family, guests, employees, and subtenants of the lessee. Statement as to how many persons may occupy the apartment and how long guests may stay. Storage space and laundry. Regulations regarding automobiles. Pet regulations. Rules for subletting, if allowed. Conditions for assignment of lease. Repairs required of lessee. Insurance requirements. Alteration regulations. Removal of fixtures. Rights of lessor with regard to apartment entry. Sale of shares. Surrender of apartment upon lease expiration. As you can see from the above list, proprietary leases can be quite complicated. Offering plan. The Martin Act applies to the sale of all types of cooperatively owned real estate. The sale of co-op shares, condo units, or interests in homeowners associations is subject to the Martin Act, as is the sale of other securities, such as stocks and bonds. The law requires that a complete description of these kinds of real estate interests be fully disclosed in an offering plan. No advertising or sales may take place unless the offering plan or prospectus, containing all the detailed information necessary for a purchaser to make a reasoned judgment about the decision to buy or not to buy, has been accepted for filing by the Attorney General. The Cooperative and Condominium Conversion Act, also part of the General Business Law, specifically regulates the conversion of existing rental buildings to cooperative forms of ownership. This law provides specific protection for tenants living in buildings undergoing conversion and requires that offering plans include explanations of the rights and obligations of both purchasers and non-purchasers. Offering plan. Before owners or sponsors may convert a rental apartment building, they must present an offering plan to each tenant and to the Attorney General. This plan is only a preliminary prospectus of the proposed conversion. It is referred to as a red herring because the legend on its cover must be printed in bold red lettering. The information contained in the red herring is subject to review and may be supplemented or changed by the Attorney General or the sponsor. Until the review is completed and the final version of the plan is accepted for filing, no sales or advertisements are permitted. Once the Attorney General accepts the plan, it becomes a black book or final offering plan. In place of the red legend that appeared on the cover of the red herring, this plan will have a statement in black lettering indicating that the plan constitutes the sponsor's offer to sell co-op or condo units under the terms and conditions set forth in the plan. House rules. Almost every cooperative has rules that direct the practices and behavior of the apartment owners and their guests. House rules are usually more detailed than the items found in the proprietary lease and deal more with the day-to-day activities of the residents. These house rules cover a variety of subjects including limitations on pets, times permitted for construction, behavior on common areas, placement of satellite dishes, loud music and television, restrictions on amenity use by children of certain ages, conflict resolution, care of apartment windows, use and care of limited common elements, such as balconies and terraces. Knowledge of the house rules is important to a real estate agent because the agent must make certain the prospective purchaser is aware of them. If a purchaser would find one or more of the rules difficult to live with, he or she may want to rethink a purchase in this particular building and look elsewhere. It is important to find out about the rules before a purchase. Alteration agreements. Under the proprietary leases used in most New York City cooperative buildings, the consent of the cooperative corporation is required for a shareholder to make any changes or alterations to his or her unit. This is done in the form of an alteration agreement. Many different forms of alteration agreement have come into use over the years, and the Committee on Cooperatives and Condominiums of the New York City Bar Association concluded that it would be useful to develop a model form of alterations agreement for cooperative corporations and their managing agents to use as a guide. This model form requires the shareholder to submit detailed plans, drawings and specifications for review and approval by the cooperative corporation and its professional engineer. If the work is approved, the model form attempts to assign all risks and costs incident to the alterations to the shareholder making the alterations, so as to avoid risks to the co-op corporation. Some of the items that might be found in the alterations agreement include the following: description of the documents the shareholder must submit, review of the plans and specifications, preconditions to the start of the work by the shareholder, amount of notice the shareholder must give before starting the work, requirements for how the work must be performed, scheduled inspections and corrections, responsibility for damages or any adverse effects, indemnification by the shareholder, shareholder to bear all costs of the work, maintenance and repair of work, requirement of shareholder to post a security deposit, ramifications of a shareholder's breach and the corporation's remedies in case of breach. Board packages. When a prospective purchaser wants to buy into a cooperative, the board will normally require a private interview along with an application packet. It may take several weeks for the board to complete their review and be satisfied that the purchasers meet their acceptance requirements. A board package normally includes the following documents: an application with basic information about the purchaser, including financial condition, 1 or 2 years of tax returns, 2 to 4 personal reference letters, 2 to 4 reference letters from work colleagues, 1 letter from a former landlord stating that the purchaser was a good tenant, 1 bank letter verifying balances and stating how long the purchaser has been a customer, a letter from the current employer, verifying the purchaser's position, length of employment and salary, the contract for sale, the mortgage commitment letter, documentation supporting the purchaser's stated financial condition. Applicants to a cooperative must realize that the board has the right to reject their application and deny the purchase for any reason, and the board does not have to tell the applicant what that reason is. Board packages. Who reads a package? Usually the managing agent is the first person to read over the package, checking it for completion before handing it off to the board members. In some co-ops the entire board reads over the documents, but more than likely, only a handful of board members will review the package. Some boards delegate the review process to a committee, which may be a subset of board members or other shareholders. However, when this happens, the committee makes a recommendation to the full board, which then makes the final decision. What is the board looking for? The board wants to know the full financial status of any prospective purchaser. Some of the things the board will be looking for include the following. Does the purchaser have sufficient income to pay maintenance payments and mortgage charges? Is there enough cash on hand to pay the non-financed portion of the purchase price? If the sale is all cash, is there enough visible cash to cover the closing costs? Does the credit report show any problems, such as defaults or late payments on credit card charges, student loans or outstanding mortgages? Does the purchaser have any excessive debt, especially on credit cards? The board will answer all of these questions using the financial documents the purchaser has submitted. Financing. In a co-op, since the purchaser is actually buying shares in a corporation rather than real estate, the purchaser gets a type of loan called a share loan from a lender. A share loan is like a mortgage. It provides the purchaser with borrowed funds to buy the shares from the seller. The purchaser then makes monthly payments on the share loan to the lenders and monthly carrying charge payments to the co-op. The purchaser pledges his or her shares in the co-op as security for the repayment of the share loan. Instead of recording a mortgage, a UCC financing statement is filed with the county clerk. The lender then takes possession of the purchaser's stock certificate. The proprietary lease is also assigned to the lender as additional security. Co-op lien search. To finance a cooperative purchase, the lender will conduct what is known as a lien search to determine whether there are any open liens filed against the seller, against the seller's shares in the co-op corporation, against the seller's proprietary lease, or against the co-op corporation itself. Lender co-op recognition agreements. A recognition agreement is a three-party contract. Primarily, it is between a tenant shareholder's lender and the co-op, which is then signed and approved by the shareholder. Some of the highlights of this contract are as follows. It certifies to the lender that the tenant shareholder is the owner of the apartment. It acknowledges that the corporation has consented to the lender making a loan to the shareholder, in exchange for which the lender has taken back a lien on the borrower's shares and lease. It prohibits the co-op from giving its consent to any further encumbrances, subletting, termination, or surrender of the lease without the lender's approval. It requires the co-op's intention to terminate the lease. It provides that the co-op must accept payment from the lender on behalf of the tenant shareholder. The co-op recognizes the lender's lien against the shares and lease. It gives the co-op the right to demand and receive a copy of the financial and credit information provided by the tenant shareholder to the lender. The lender acknowledges that it has no right or power to transfer the shares and proprietary lease to anyone without the co-op's approval. It provides that notices under the agreement that are required to be sent to the co-op will be sent by registered or certified mail care of the managing agent. Check your understanding. Print this screen, answer the questions and then advance to the next screen to see the answers. 1. What is a subscription agreement? 2. What do co-op purchasers receive instead of a deed to the property? 3. Name 4 items that are normally included in a board package. 4. What is a share loan? Check your understanding. Answers 1. What is a subscription agreement? The contract to purchase the shares in a cooperative corporation. 2. What do co-op purchasers receive instead of a deed to the property? A long-term proprietary lease. 3. Name 4 items that are normally included in a board package. An application with basic information about the purchaser, including financial condition, 1 or 2 years of tax returns, 2 to 4 personal reference letters, 2 to 4 reference letters from work colleagues, 4. What is a share loan? A share loan is like a mortgage. It provides the purchaser with borrowed funds to buy the shares from the seller. The purchaser then makes monthly payments on the share loan to the lenders and monthly carrying charge payments to the co-op. Application and interview preparation. Once the buyer makes a purchase offer and the seller agrees to the contract and it is signed by both parties, it's time for the purchaser to assemble the board package we talked about earlier. The board package checklist includes purchase application form, which includes all the basic information about the purchaser. The board may request a separate form from the seller with information about the specific unit. Fully executed contract for sale. Financial statement verifying all assets, which must be authorized by the purchaser in writing. Letters of personal reference. Employment verification letter. Business letters of reference. Tax returns. Credit search. Important New York disclosure forms. Residential lead-based paint disclosure for properties built before 1978. Smoke detector, carbon monoxide detector, affidavit. Agency disclosure forms if the cooperative has 1 to 4 units. Preparing for the interview. Once the board package has been accepted, the directors will most likely want a face-to-face interview with the purchaser. The interview can be done in front of the entire board or with a subset of board members designated specifically for this task. Interview issues. Timing. Most boards meet once a month. If the board only conducts interviews at its scheduled meetings, it would be important for the purchaser to have the package completed in enough time for the managing agent to review it and submit it to the board before their next scheduled interview meeting. If the board schedules interviews as applications are accepted, then this is not an issue. Familiarity with complete package. It's important for the purchaser to be able to discuss anything and everything that is contained in his or her board package. More than likely the board members will probe further and ask more detailed questions of the purchaser, particularly regarding the financial components. They may also ask other questions concerning the number of people who will actually be living in the apartment, whether the purchaser has or plans to have pets, and what the purchaser's motivation was for choosing this particular cooperative or unit. The real estate agent can play an active role in helping the purchaser prepare for the interview. The agent can be particularly helpful if he or she has previously sold units in this same cooperative, as he or she might have insight into the types of questions the board members will be asking. Total disclosure. It's critical for the purchaser to answer all questions truthfully, while not disclosing information that was not asked for. If the board should discover something that would exclude the purchaser from owning the unit, the closing may not happen. The interview is the place to verify the information that was submitted in the application and to impress the board members. Primary residency versus subletting. The owner of the cooperative unit is the primary resident. Since primary residents tend to take better care of their units, most co-ops prefer that the units are not sublet to non-shareholder tenants. Cooperatives that allow sublets have some potential negative issues to deal with. If the percentage of sublets is high, the cooperative may not be able to borrow money easily or refinance its underlying mortgage without paying much higher rates. Purchasers in these cooperatives may have more difficulty getting share loans or may have to pay much higher rates to get them. Conversely, subletting has its benefits. At any given time, one or more individual shareholders in a building may have a change in circumstances that requires them to relocate, an increase in family size, a job opportunity out of town, an adverse change in economic circumstances like the loss of a job. A sublet allows that owner to collect the rent needed to make the maintenance payment. In many cases the board will review the financial status of the potential subtenant to be sure he or she has the ability to make the rent payments to the shareholder. The shareholder is still ultimately responsible for making the maintenance payments to the cooperative. Subletting issues. Some co-ops are generous in allowing subletting, but most cooperatives severely restrict subletting in order to preserve the owner-occupant character of the community. Co-ops that do allow subletting often have restrictions on the length of time for which the shareholder owner may sublet the unit. The policy can usually be found in the Occupancy Agreement or Proprietary Lease. The cooperative may decide to put a ceiling on the number of units that can be sublet at any one time. If they adopt this policy, all sublet applications that come in after the ceiling is reached will be rejected. Another rule the cooperative may put in place is the requirement that a shareholder reside in the building for a set period of time before the unit could be sublet. For example, the requirement may state that a shareholder must reside in his or her unit for 3 years in a 5-year period. A board may prohibit subletting entirely if the governing documents allow it. As with prospective purchasers, the board has the right to deny a sublet application without giving a reason. A board would only have to defend its decision if the board is sued or if the decision is challenged by a human rights group. Suits and other challenges usually occur only with a claim of discrimination. Other subletting issues. Sponsor shares. In some cases, the bylaws or rules of the cooperative will allow a sponsor who owns the shares allocated to a unit to sublet that unit, even though other unit owners may be prohibited from doing so. The rules for sponsor subletting are generally part of the offering plan. Holder of unsold shares. Almost every offering plan provides for a special class of shareholders called holders of unsold shares, who are routinely granted privileges not enjoyed by the typical tenant shareholder. Unsold shares are shares of stock in a cooperative, which are allocated to apartments that have never been purchased for residential use. In the case of a conversion project, unsold shares are those shares of stock allocated to any apartment not purchased by an insider tenant at conversion. They become unsold shares immediately following conversion and the sponsor keeps them until they can be sold. They maintain their status as unsold shares for as long as the apartment is owned by the sponsor, or by any of his subsequent purchasers who have acquired the apartment for investment purposes. As we said, holders of unsold shares are exempt from many forms of board regulation. They are not required to submit their prospective purchasers to the board for its approval, nor are they bound by the board's sublet restrictions. They're also exempt from paying sublet fees, alteration fees, transfer fees and flip taxes which may be imposed on the typical tenant shareholder. Sold shares. Once the sponsor or a member of his family occupies the apartment as a residence, or an outside purchaser buys it as a residence, the stock no longer qualifies as unsold shares. The shares are now sold shares. Condops. What is a condop? A condop actually has 2 definitions, a legal one and one used by many real estate brokers. The legal definition of a condop is a building which has been divided up into mixed-use segments, with each segment receiving a condominium unit deed. Subsequently, one of these segments is identified as a residential component that is owned by a cooperative corporation. This residential component is therefore referred to as a condop since the cooperative corporation effectively owns a condominium unit deed rather than a fee simple interest in the land. The other definition of a condop, used by real estate brokers, refers to cooperative apartment buildings that essentially operate under condo rules, that is, they do not have board approval requirements or restrictions on rentals. These buildings are viewed as hybrids in that the ownership form is a cooperative corporation, but the procedural characteristics are similar to a condominium. Condops. Why condops are created? Condops were first created in the early 1960s, when New Yorkers were still wary of the concept of residential condos, but developers wanted to divest the residential parts of their buildings while retaining or separately divesting the commercial parts. Today, some condops come into being as original construction, with the developer setting up the condominium, transferring the unit containing apartments to a co-op corporation, and then either keeping or selling the unit containing commercial space. Condops have also been created in existing buildings by sponsors who convert a rental or commercial property into a condominium with 2 or more units and then convert one of those units into a co-op for residential use. There are some situations in which a conversion to a condop might be worthwhile. One such situation might occur when commercial space in a co-op becomes so valuable to the tenant leasing it that the tenant is willing to buy the space from the co-op for much more than the space is worth. For example, if a retailer has a good location, he or she might be willing to pay a premium to buy the property and then never have to worry about the lease expiring. And if the co-op has a small underlying mortgage, it might make sense for the co-op to sell the space to the tenant, pay off the mortgage and beef up its capital fund. Condops. The 80-20 rule. Another incentive for a co-op to consider converting to a condop is the potential for such a conversion to solve a problem faced by many co-ops that have significant income from commercial tenants, the so-called single quote 80-20 problem. The IRS 80-20 rule is a federal tax rule that requires residential co-ops to get at least 80% of their gross income from their tenant shareholders and no more than 20% from other sources like commercial rents. If this rule is met, shareholders can enjoy the same tax benefits available to homeowners, such as the $250,000 per person exemption on the gain on sale of a residence, tax deductibility of interest paid on the shareholder's apartment loan, interest paid on the co-op's underlying mortgage, and real estate taxes paid by the co-op. On December 20, 2007, President Bush signed into law the Mortgage Forgiveness Debt Relief Act of 2007. The law contains an amendment to the section of the Internal Revenue Code that deals with the 80-20 rule. Now, a co-op can also qualify if, for the tax year in question, one of the following is true. At least 80% of the total square footage of the co-op's property is used or available for use by shareholders for residential or residentially ancillary purposes. At least 90% of the co-op's expenses are for the acquisition, construction, management, maintenance, or care of the co-op's property for the benefit of its shareholders. Check your understanding. Print this screen. Answer the questions and then advance to the next screen to see the answers. 1. Who is present at the board interview? 2. Under what circumstances might allowing subletting in a cooperative be a good thing? 3. What privileges are granted to holders of unsold shares? 4. What is a legal definition of a condo? Check your understanding. Answers 1. Who is present at the board interview? Either the entire board or, more likely, some subset of board members designated to perform this task and then report back to the full board. 2. Under what circumstances might allowing subletting in a cooperative be a good thing? At any given time, one or more individual shareholders in a building may have a change in circumstances that requires them to relocate. A sublet allows that owner to collect the rent needed to make the maintenance payment. 3. What privileges are granted to holders of unsold shares? They are not required to submit their prospective purchasers to the board for its approval, nor are they bound by the board's sublet restrictions. They are also exempt from paying sublet fees, alteration fees, transfer fees and flip taxes which may be imposed on the typical tenant shareholder. 4. What is a legal definition of a condo? A building, which has been divided up into mixed-use segments, with each segment receiving a condominium unit deed. Subsequently, one of these segments is identified as a residential component that is owned by a cooperative corporation. Summary review. This concludes Chapter 27. Below is a summary which you can review before taking your quiz. A condominium is a building in which each owner has a percentage ownership of the entire property. The condo is for legal purposes real property. The condo owners own an undivided percentage of the common elements of the building along with the other unit owners. The condo is governed by a board of directors or board of managers that maintains the common elements and enforces the regulations. Condominium documents are generally divided into 3 parts: declaration, articles of incorporation, and rules and regulations. The bylaws are the basic rules under which the condominium operates. The condo's sponsor is the condo's owner or developer. The sponsor appoints the board members, appoints the managing agent, and puts a limit of his or her own control of the board. An offering plan, also known as a prospectus or black book, must be reviewed by the New York State Attorney General's office to be sure the information is accurate and complete according to New York State legal requirements before the plan can be distributed to the public. Summary review. Summary: a letter of intent is a written statement expressing the intention of the undersigned to enter into a formal agreement to purchase a condominium. A letter of intent contains the following information: price and deposits, completion date and closing date, use of the unit, non-exclusivity. A new building cannot be legally occupied until the building department has issued either a final or a temporary certificate of occupancy. If a temporary certificate of occupancy expires and is not renewed, a new buyer may find it difficult or impossible to renew his or her homeowner's insurance policy or to sell or refinance the home. Flipping is the act of buying a unit from a developer as soon as it comes on the market and then reselling the contract to a third party before closing occurs. Flipping is a quick turnaround of the unit for a faster profit, but it may only be done with the developer's permission. Flipping can drive up the prices on the units in a development. It can cause financial problems for buyers who purchase the flipped units for much more than they would have paid if they bought directly from the developer. Summary review. Summary: a lender will require title insurance to protect its interest in the condominium unit. The title search will protect the buyer against any unpaid bills or liens against the condominium association. To qualify for a mortgage loan, a borrower must meet the lender's qualifications in terms of income, debt, cash, and net worth. In addition, the borrower must demonstrate sufficient creditworthiness to be an acceptable risk. The main difference between a cooperative and a condominium is the form of ownership. While a condo owner actually owns the unit, which is treated as real property, a co-op member does not directly own any real estate. The corporation owns or leases all real estate. Each unit in a cooperative is allocated a number of shares of stock. When buying into the co-op, a person is buying those shares in the corporation. Each month the shareholders pay a maintenance fee that covers their share of the operating expenses of their cooperative corporation. Co-op members are entitled to a tax deduction for their portion of the building's real estate tax, their portion of the building's interest payment on its mortgage, and the interest payment on their own apartment loan. Summary review. Summary: potential buyers should review the co-op's annual financial statement, with the help of their attorney or an accountant, before signing any contract. The financial statement should include the following: accountant's opinion letter, statement of financial position or balance sheet, income statement. Notes to the financial statement. Reviewing the board's minutes can be very helpful for prospective buyers. The board may discuss maintenance issues and make decisions about whether they will need special assessments during the year to cover certain expenses. Reading the minutes will give the prospect an idea of what maintenance issues are of concern to the cooperative board. Reading the minutes may also give the buyer information about the status of the mortgages that can't be found in the financial statements, as well as information about the reserve funds. For the co-op corporation, the ownership of the building and all of the common elements is a fee simple ownership. For the shareholders, their interest is a leasehold estate. Some cooperatives have a flip tax that is imposed when the unit transfers. A flip tax is not really a tax but a fee for the sale of a co-op unit. Summary review. Summary: the documents typically needed for a cooperative transfer include subscription agreement, proprietary lease, articles of incorporation, bylaws, house rules. When the purchaser closes on a purchased unit, he or she will receive stock certificates in his or her own name. Co-op purchasers do not receive a deed to their property. Instead, ownership of the shares entitles the purchaser to a long-term proprietary lease for the apartment or unit. The consent of the cooperative corporation is required for a shareholder to make any changes or alterations to his or her unit. This is done in the form of an alteration agreement. When a prospective purchaser wants to buy into a cooperative, the board will normally require a private interview along with an application packet. In a co-op, Since the purchaser is actually buying shares in a corporation rather than real estate, the purchaser gets a type of loan called a share loan from a lender. A recognition agreement is a three-party contract. Primarily, it is between a tenant shareholder's lender and the co-op, which is then signed and approved by the shareholder. Summary review. Summary: most co-ops prefer that the units are not sublet to non-shareholder tenants. Cooperatives that allow sublets have some potential negative issues to deal with. For example, if the percentage of sublets is high, the cooperative may not be able to borrow money easily or refinance its underlying mortgage without paying much higher rates. Co-ops that do allow subletting often have restrictions on the length of time for which the shareholder owner may sublet the unit. In some cases, the bylaws or rules of the cooperative will allow a sponsor who owns the shares allocated to a unit to sublet that unit, even though other unit owners may be prohibited from doing so. Holders of unsold shares are exempt from many forms of board regulation. They are not required to submit their prospective purchasers to the board for its approval, nor are they bound by the board's sublet restrictions. They are also exempt from paying sublet fees, alteration fees, transfer fees and flip taxes which may be imposed on the typical tenant shareholder. Summary review. Summary: a condop is a building which has been divided up into mixed-use segments, with each segment receiving a condominium unit deed. Subsequently, one of these segments is identified as a residential component that is owned by a cooperative corporation. There are some situations in which a conversion to a condop might be worthwhile. The IRS 80/20 rule is a federal tax rule that requires residential co-ops to get at least 80% of their gross income from their tenant shareholders and no more than 20% from other sources like commercial rents. On December 20, 2007, President Bush signed into law the Mortgage Forgiveness Debt Relief Act of 2007. The law contains an amendment to the section of the Internal Revenue Code that deals with the 80/20 rule. Now, a co-op can also qualify if, for the tax year in question, one of the following is true. At least 80% of the total square footage of the co-op's property is used or available for use by shareholders for residential or residentially ancillary purposes. At least 90% of the co-op's expenses are for the acquisition, construction, management, maintenance or care of the co-op's property for the benefit of its shareholders. Click here if you would like to open this summary as a PDF, which you can then print or save to your device. Chapter 27 Summary Chapter Conclusion. In this chapter, we have discussed definition of a condominium, condominium organization, title issues and condominium purchases, definition of a cooperative, various documents needed for the sale and purchase of a cooperative, the process for applying to the cooperative board. Have you requested an appointment for your proctored course final exam? Complete this form to request an appointment. Your proctored course final exam must be scheduled in advance, so don't wait until the last minute to request an appointment. Consult the New York Final Exam Proctor Instructions document and your helpful resources for more information. In the next chapter we'll discuss the various types of investment properties. Now it's time for your quiz. Good luck! 1 of 21. When an apartment building is being converted into condominiums, how long do current tenants have exclusive right to purchase their apartments? 90 days. 2 of 21. To market test a condo, the sponsor must file an application to test the market with the NYS Attorney General's office. 3 of 21. In a new building, when does the sponsor have to submit an amendment to the Attorney General? Only if the price changes for all units or a section of units. 4 of 21. The Attorney General does not have the right to regulate the prices of condos. 5 of 21. What are the 3 documents that are considered the legal blueprint of a condominium? Declaration, Articles of Incorporation, and Rules and Regulations. 6 of 21. Along with the amount of income, what else do banks want to see in a borrower's income? Stability and permanence of the income. 7 of 21. Which of the following fees are not the buyer's responsibility? Transfer tax, 8 of 21. Which of the following is not decided by the condominium sponsor? Whether to have a board or not. 9 of 21. When can the sponsor retain board control until all units are sold? In a new development. 10 of 21. The sale of co-op shares, condo units, or interests in homeowners associations is subject to the Martin Act, as is the sale of other securities, such as stocks and bonds. The law requires that a complete description of these kinds of real estate interest be provided in an offering plan. 11 of 21. What are the 3 essential characteristics of a condominium? Real property, common elements, and a board of directors. 12 of 21. What information is not included in a proprietary lease? Transfer of deed. 13 of 21. The consent of the cooperative corporation is required for a shareholder to make any changes to his or her unit. This is done in the form of an alteration agreement. 14 of 21. A temporary certificate of occupancy is typically effective for after the issue date. 90 days. 15 of 21. What is a black book? Offering plan. 16 of 21. The document that describes the way the condominium is governed is called a declaration. 17 of 21. AN provides the purchaser with borrowed funds to buy the shares from the seller. The purchaser then makes monthly payments on to the lenders and monthly carrying charge payments to the co-op. Share loan. 18 of 21. Most co-op buildings have one or more mortgages on the entire building. This is known as the underlying mortgage. 19 of 21. What typically happens once the cooperative's board package has been accepted? A face-to-face meeting of the purchaser with the board. 20 of 21. Greta has owned several condominiums in the last 3 years. She lives in them for a couple of months and then sells them for a profit. What is this called? Flipping. 21 of 21. A condominium owner's share of the common elements is typically determined by the square footage of the owner's unit.